This is CV 2025-017500, Social Service Contractors Indemnity Pool versus Rofe et al. And related claims. I'll take the appearances for the plaintiff's counter-defendant.
This is Gina Sluga for the Social Service Contractors Indemnity Pool and Berkeley Risk.
Good morning. I'll take the appearance for the MedStar defendants counterclaimants.
Your Honor, Stephen Guy here for the MedStar defendants counterclaimants.
Good morning, and I'll take the appearance for the intervener Kogelmeyer Law Group.
Good morning, Your Honor. Theodore Horwitz for the intervener Kogelmeyer Law Group.
Good morning. This is the time set for a Rule 26D conference. And first of all, let me say thank you for everybody for your patience. We had to push this back 15 minutes. We had an oral argument that ran long. So I've reviewed the joint statement of discovery dispute, the joinder, the supplement, and the response. That's everything that I've received. And my understanding of what we have is, first of all, the interests of the intervener and MedStar are aligned based on what's been filed. And we have the intervener seeking to get the claims file from the insurance company. And it looks like from the supplement that may have been provided now, but there's been a privilege log provided with some withheld documents based on things that may not be privileges, such as trade secret protection, et cetera. Is that essentially where we are, Mr. Horwitz?
That's correct, Your Honor. Essentially, Skip's response narrowed the dispute quite a bit. It's offered in-camera review, but at the same time, it's told the court that its trade secret designations were made, and these are its own words, in order to ensure that those privileges are not waived. It also alleged that the redactions are primarily based on the fact that the information redacted is not relevant. Realistically, this comes down to the privilege law, like you said. Rule 26b-6 requires a party that withholds otherwise discoverable material to describe it so that other parties can assess the claim. FAN, which is cited in the papers, holds that the burden of proving each element is on the party asserting the privilege and that the log's descriptions must entail more than generalities. In response to that, at page 5 of Skip's response, Skip tells this court it is not required to provide facts supporting the privilege. That is the dispute.
Okay. Mr. Guy, anything that you wish to add? You're muted.
Your Honor, let me just say, if it's not clear, we join in all respects with what interveners have filed, and we're asking for the same relief. The only thing I would say is one of the relevancy objections, which I agree is not a valid objection at this stage for discovery, but one of the things had to do with the agreement between Skip and Berkeley Risk. And basically, as I understood Skip's and Berkeley's argument, that only the portions of that agreement that relate to claims functioning is relevant and not underwriting and other functions that were being performed under that administrative services agreement. And that is just not correct. Those other portions are very relevant to our third-party claims against Berkeley Risk, and many of those issues are up on a petition for review in the Wagner case to the Supreme Court. But at this point, we think that entire agreement should be produced unredacted.
Okay, Ms. Sluga.
Yes, thank you, Your Honor. Let me start, Your Honor, by saying that this entire dispute, I think, was filed prematurely. Mr. Horwitz knew that we were working with Mr. Guy to be sure that before we produced the claim file regarding a claim against his client in the underlying case, that we knew his position with respect to the privilege that his lawyer had with retained defense counsel. And we produced the claim file 24 hours after learning Mr. Guy's position with respect to privilege. But Mr. Horowitz had already filed this discovery dispute. 24 hours after we produced that claim file, as everyone knew, I was out of the country for 2 weeks. First for professional obligations and then on a vacation. So my colleague Asha, who's also with us here on the line as counsel for Skip, worked very hard with opposing counsel to do 2 supplements of the privilege log, a supplemental production, and to try to work on all of this in my absence. But I'm surprised to hear Mr. Guy say today that underwriting is relevant to this case. I have no idea how underwriting is relevant to this case. We really haven't had opportunity to even confer about these issues. What I can say to you right now is I am aware of only 3 disputes before this court about discovery. The first we can talk about is there are 5 pages of over 200 pages of claim file notes that were withheld because they include the client's descriptions of conversations with me about this case. We have given the dates of those conversations, we've given the name of the person who spoke with me, and that yes, they were conversations with me for legal advice about this very case. They want more information about what I was talking to my client about during those conversations. I can't give more without waiving privilege. If this court would like to see those 5 pages to ensure that they were in fact attorney-client communications, we would be honored to provide the 5 pages to this court for in-camera inspection. But they were conversations with me about this very case for legal advice about this case, and I have shared that information. I don't know what else they need to know. 5 pages out of well over 200 pages of notes is all that was withheld for this. I don't understand what they're confused about. They're privileged communications with me. That's the claim file notes. With respect to the claim handling guidelines, the only parts that were withheld are parts about how to adjust a workers' compensation claim or a claim with a significant self-insured retention, neither of which have anything whatsoever to do with this case. The underlying case was not a workers' compensation case and did not involve a significant SIR. So I don't understand why we would be asked to produce claim file guidelines on how to handle a workers' compensation claim. That has nothing to do with this lawsuit. We provided everything else in the claims manual. And with respect to the contract between Skip and its third-party administrator, we were asked to produce the material, the contract between them. And we produced the contract and everything in the contract that would have anything to do with how the third-party administrator handled this claim. And that's what this is, a bad faith claim. We are unaware of any allegations regarding underwriting issues or any other issue in this case. But as Mr. Guy mentioned, he's involved in a different lawsuit with this third-party administrator. And he can't use this case as a fishing expedition for that one. If he thinks that underwriting is relevant to this case, now that I'm back in the country and available to meet and confer, we need an opportunity to do that. Because as of right now, with respect to that issue, I absolutely don't understand that why the parts that we've withheld, the handful of redactions, have anything whatsoever with the dispute about this before this court.
Okay, let me address the issues. Let me start with the claim file notes that there's an allegation of privilege or a claim of privilege. Those have been withheld. It would be premature for me to review those in camera under the Arizona Supreme Court case law. There's a process we have to go through. There's a privilege log has been prepared. It sounds like it identifies who the parties to the communications are when those communications occurred. And
Your Honor, if I may, and I hate to interrupt you, that's part of the issue. The privilege law does not identify those individuals. In fact, Ms. Sebastian's responsive email to me when I asked for the privilege log to properly identify the individuals listed was that it was my job to go back and recreate from 1,500 pages of disclosure the individuals in these communications. The point is, Your Honor, every single time Skip has had an obligation under the rules of civil procedure. It has taken either the threat of filing or a filing to get them to perform. Whether Ms. Sluga was on vacation or not.
Okay,
was not
let me stop you, Mr. Horowitz.
understood.
Okay, because I've heard enough to give the parties guidance as to what I'm going to do here. Okay, so Ms. Sluga, if the privilege log does not identify who was on the communications, it needs to do that. It needs to identify the communications, who was a party. That way, the other parties can evaluate whether they think the privilege has been waived because there were non-client representatives, et cetera. So there has to be an appropriate privilege log provided. And then if somebody wants to challenge the assertion of the privilege, there's going to have to be a motion filed to do that. And then I'm going to have to determine whether there's a prima facie assertion of the privilege, and then somebody who's asserting that the privilege doesn't apply will have to take appropriate steps. You have to look at the case law on that. But I can't just review documents in camera to determine the privilege. The case law makes it clear that that's not appropriate to do. So we're going to follow the three-step process, I believe it is, to determine whether the privilege applies, and if so, if it did apply, whether it's been waived, etc. So you'll have to follow that procedure. Regarding the redactions of documents or claims of trade secret or relevance, I'll tell you my view on discovery is that it's broad. Relevance objections usually don't carry the day because the scope of discovery is broader than the scope of admissibility. And trade secret is not a privilege that I'm aware of. If you can find case law that says that's an appropriate privilege that can be asserted and a basis to withhold documents, you'd have to provide that to me. But trade secrets, that's a basis for confidentiality. We have a protective order in place. And regarding the use of documents from this litigation for other litigation, I don't have the protective order in front of me, but it probably limits confidential documents use to this litigation. I'm presuming that it does, and limits who can have access to that. So that's the framework that I'm looking at this through. It's going to be difficult for me to order specific relief other than if the Ms. Sluga, does your privilege log identify the parties to the communications and identify the communications by date?
I believe so, but Your Honor, I'm just back in the country. Like I said, I've been gone. I will personally lay eyes on it today. I will personally ensure that that is the case. And if we need to supplement, that will happen within the next 24 hours. But I believe that with respect to these 5 pages, that it is clear. For instance, there's a couple of them here in front of me where they know who drafted the note, and the note says things like, "I spoke today with Gina Sluga." And then we start the redaction. So they know who drafted the note. They know who said they were talking to me. All of that is there. But I will personally lay eyes on all of it and make absolutely sure we are compliant within the next 24 hours.
So what I'll do is order a supplemental privilege log, unless you determine that it meets the standards under the applicable rules.
Yes, sir.
And then you need to notify everybody of that. Now, I want to make sure that you said 24 hours. I mean, is that really going to be enough time? Do you want me to give you until close of business on Friday?
You can
Or-
put close of business Friday for the deadline, but I anticipate we will do it within the next 24 hours because again, it's 5 pages, Your Honor.
Okay.
We've produced a great deal of material in this case.
Well, okay, and I understand those 5 pages, but if the privilege log is also asserting trade secret as a privilege or relevance as a basis for withholding documents, you need to revisit that based
Yes, Your
on
Honor.
what I've just laid out. So tell me, because it may go beyond those 5 pages, how much time do you reasonably need to accomplish that whole task? I don't want to piecemeal it.
End of business Friday is sufficient, Your Honor. Thank you.
Okay, so that'll be the deadline for doing that. And then the other parties, the intervener and MedStar, they'll have to take the next steps. And once you receive that, you'll have to review it. If you think that there's a deficiency, then you need to meet and confer with Ms. Sluga. If you think that documents have been inappropriately withheld because they're not appropriately privileged, you'll need to meet and confer. If you do that and you can't resolve that, I don't think I'm going to be able to resolve the issue further with another Rule 26D conference. I really want the parties to try to avoid having to have extensive motion practice on this, but I think that's the next step. But you have to meet and confer regarding the issues. I've tried to give you some guidance as to my views on discovery to help you resolve that through the meet and confer process. Any questions, Mr. Horowitz?
Yes, actually, Your Honor, I do have a few questions and clarifications. First and foremost, if we could specifically enumerate exactly what Skip and Berkeley Risk have to serve in their amended document, and I'd be happy to lodge a proposed order. For example, for every entry withheld or redacted in whole or in part, that log should name the author, every recipient, including everyone copied, any third party to the document. It should give the date, the complete Bates range of the document rather than the withhold portion alone. It should describe the subject matter in terms sufficient to let the claim be assessed, and things of that nature. In addition, we would ask that any order respectfully reserve the right of any party to seek additional relief under Rule 37 by separate motion, which is consistent with this court's protocol.
Well, that's what I just said, basically, about the motion after you meet and confer. If you think that there hasn't been compliance, then I've authorized the filing of a motion, although I'm encouraging the parties to be able to resolve the issue based on the guidance I've laid out. Ms. Lugo, regarding the contents of the privilege log, I think essentially what Mr. Horowitz described is what I envision in a privilege log. Did you want to be heard on that? Go ahead.
I would like to be heard, yes. I think this is part of our disconnect. The 3 documents that I understand to be at issue right now are a contract, a manual, and claims notes maintained in a system. No one receives those documents. No one sends it. No one receives it. It's a contract. It's a claims manual. It's not, this isn't about email exchanges and such. So
okay.
I don't want the order to say I have to put all of the recipients. There aren't recipients.
Okay, so for the claims log, or the privilege log, that is for privileged communications, which are asserted to be, or for communications that are asserted to be privileged. If you're claiming a privilege, and I don't know how you would do it on a contract, that would be different because it's not a privileged communication. It's a written document with independent legal significance. It's not a privileged communication. And that's why I said I don't think that would be a privileged communications, and it should be produced. It could be designated confidential under the protective order. So that's my comments about the privilege log are really geared towards communications that are withheld on privilege grounds.
I understand the court's position, and I'm pleased to and will comply. My only point is when Mr. Horowitz asked for an order that says we have to do certain things with each document, my point is I don't think an order should specify that because the things he's asking for don't apply to much of what's in this dispute. So we will comply with the privilege log. If he disagrees, he can meet and confer, but I don't think the order can list everything he's asking for because this isn't one-stop shopping. These are different kinds of documents with different issues and different objections.
Well, I'm not going to issue a separate order. There'll be a minute entry that sets out what I've required. And I've told you my expectations for what the privilege log should contain.
Yes.
That says to communications withheld on privilege grounds.
Yes.
And it's essentially what Mr. Horowitz indicated, the, who authored the document, who received it, the date of it, and the general nature of what it is.
Yes, Your Honor.
Right. So that's the way we're proceeding. And with that, that'll conclude the Rule 26D conference. Thank you, everybody.
Thank you for your time, Your Honor.
Thank you, Your Honor.